let me let him talk.
Wait, hang on. Counsel, is that in one of your exhibits? Like a breakdown?
No, Your Honor, that's not in one of my exhibits now, Your Honor, because it wasn't an issue.
All I can do is wish you guys, good luck in the future.
Yeah, I don't need luck, and God don't answer wishes. God answers prayers. So thank you very much, Judge Marable, and you have a blessed day.
Well, thank you, I think. Professional property management versus Penn and Chapman. I thought we were here on this week.
We were.
All right.
Still here.
So did we get Miss Penn into the Zoom?
I'm here, sir. How you doing, Judge?
Okay. I'm fine. Now, did you guys speak at all about this?
I'm sorry, I couldn't hear you.
Have you guys talked about this today?
Not today. We did speak with you and each other last time we talked, but we have not got a chance to speak with one another today.
All right. I granted a default judgment on February 20th because you did not appear.
Judge, I believe Miss Penn is frozen now and she's muted again.
Frozen and muted.
Mm-hmm. Yes, she is.
Is she outside now?
She's outdoors somewhere and I don't know. She's moving around some.
Wow, it's sunny. I haven't seen a window since this morning. I cannot hear you, Miss Penn. I can see you outside, but I can't hear anything.
She needs to unmute, sir.
Is she frozen again?
She's frozen at the moment.
Frozen again.
Now jump to her being in a vehicle, maybe. She might need to plug her device in so that it has more power.
Okay. I can see her. I can't hear her, though.
Is it me?
I'm talking about Penn.
Okay,
Ms.
Your Honor,
Penn.
I'm here.
Okay. Let me back up. January 8th, everybody was here. All right?
Yes, sir.
I think I had set aside the default as it applied to you. Gave you 30 days to respond. Did you do that?
Are you talking to me, Your Honor?
Yes, ma'am.
Okay, I'm sorry, I didn't hear the question you asked. I apologize.
January 8th, 2020. I had set aside the default. You were supposed to file an answer. Did you ever file an answer to this lawsuit?
I believe we did. Your Honor, when I was in the courtroom with you last time, we did a default and I added Mr. Chapman and me name on there, but I'm not exactly sure.
Ma'am, you're telling me you don't know if you filed an answer to the lawsuit? Is that what you're saying to me?
I'm telling you, I'm not sure, Your Honor. I'm not. What answer was I supposed to file? All I know is that we were in court. We came to almost a decision, and then after that, it went back to a motion. That's all I'm aware of, Your Honor. I don't know anything about the legal terms or a default or anything in that category.
Okay. Well, you ended up with a default judgment again on July 2nd of 2020.
Judge, the JIS system shows that she may have filed an answer November 15th of 19.
Johnny, you're going to have to be quiet.
Okay. Well, let's go to the motion that you filed for today, Ms. Penn.
Yes, sir.
Your motion was for
just the balance
you
that we were.
You disagree with the amount or you want a motion for balance owed.
Yes,
So
sir.
basically, you want to know what the balance is that is owed on this judgment.
Yes, and also when we were in front of you last time, we came to the understanding that there was no damages. So I was confused on why there was damages being charged to me if there was no damages in the apartment.
Counsel, what's your response? Well, first of all, ma'am, did you get the plaintiff's answer to your motion? They filed a response to your motion that is, let me see here. It's about 9 pages long, plus there's a couple of exhibits. Exhibit A, Exhibit B. Did you
And
get
that's
that?
explaining the balance, right, Your Honor?
What's that?
Is that explaining the balance? Because I did receive that 9-page paperwork from them, but that still doesn't have anything to do with the damages that they're trying to charge me for when there was no damages in the apartment. So it's just a few things that I would like for them to clear up, and I would have no problem with making payment arrangements. But I didn't leave any damages. My house stayed clean.
That ship has sailed.
Okay, so I'm confused on what's next, Your Honor. I'm not a lawyer. I don't know.
Okay. Let's go back. You had the opportunity to contest the lawsuit. And they had defaulted you.
They told me to file a motion. I filed 3 motions. If I was to,
I think I sent the default.
I asked the court.
You had filed an answer, but you didn't respond to the later part of the lawsuit. So I don't. Counsel, what's your response?
Your Honor, you're correct. She eventually filed an answer after you lifted the default and then again defaulted. According to the records I have, although I wasn't counsel of record at the time, she failed to respond and then appeared and then failed to appear regarding a motion for summary disposition, which Your Honor ultimately granted in her repeated default. Per these records, there were several notices of hearings, and then she appeared and then she didn't appear. But further
every time I appeared, the court was closed. It was COVID. And every time I received another letter with a different date. I have been to court for this 10 different times. I filed 3 different motions. I have went downtown and talked to several different people. Everybody is saying different things. So if I was to attest to the lawsuit, then that's, if I asked for help, why they didn't tell me that? They told me to file for another motion. So I sat here and I filed for 3 different motions when that's not even what I needed to do, Your Honor.
Your Honor, if I might further respond to the specific point that the defendant is making, I'm looking at the breakdown sheet of the total, the sum, if you will, of the damages that we sued for and were awarded. And the portion which is actual damages is of the $3,052 outstanding. The actual portion of that's listed as damages is $140. If the defendant is willing to come up with a payment for the balance of that, I'm sure my client would be happy to compromise on that
You mean
amount.
court cost of 140? Court cost?
No, Your Honor.
It's damages and there was no damages.
Physical damages to the property is $140. So,
Your Honor, when we were, let me let him talk.
Wait, hang on. Counsel, is that in one of your exhibits? Like a breakdown?
No, Your Honor, that's not in one of my exhibits now, Your Honor, because it wasn't an issue. It didn't come up in her motion. So I'm simply addressing what she's verbally placed on the record. Now, I'm looking at the breakdown of the $3,052, which is the balance of my judgment. And just to anecdotally address the point she's making, $140 is physical damage. The rest of it is unpaid rent. and
Unpaid
court
rent,
costs.
unpaid rent and court costs.
Yes, Your Honor.
Okay. Okay, ma'am, go ahead.
Okay, Your Honor, I'm sorry. But the last time we were in front of you, we came to agreement that the damages were never any physical damages. That was just some other fees that should have been under court costs. So I'm getting charged 140 for physical damages that was never made to the property. The property was the exact same way it was when I first moved in. I was only there for about 3 months.
Okay, so he said he's willing to knock that off.
Okay, but
Was there unpaid rent?
This case shows how confusion and missed deadlines can spiral out of control. The defendant struggles to understand filings and procedures, while the court tries to keep things organized. Miscommunication and repeated defaults make resolution difficult, even when both sides want to compromise. Clear communication and accountability are essential in court, or things just keep dragging on.
He's saying it's still
Was there unpaid rent?
3,500. I can't hear you.
Was there rent that you didn't pay that you owed?
Okay, I can understand that, but this paper says $2,959. Where did he get $3,052? So now it's more being added. And if that's the case, if you're going to take the 140 off, then that's going to be 2,800, right? I'm just trying to. I can pay the balance, but I just want it to be fair. This is not fair.
This is what I'm
I pay the late fee. I pay the break.
This is what I'm going to do. You see, this is not. This is something that I don't understand why counsel and the defendant didn't have a conversation when she made
tried,
this
Your
motion.
Honor, it went nowhere.
So you guys tried to get some kind of a consent.
Your Honor, I have a judgment.
Months ago.
We spoke on the phone, and she just keeps going and going, Your Honor. She's not paying. I mean, she knows where to send the check. She knows where to call the number to work it out. She's not taking me up on any offer. She's simply calling and complaining.
And I have no problem with paying, Your Honor, but they got charges on here that's not correct to be paying for damages, and the house was the same way it was when I moved in.
Well,
we already established that when we was in front of Judge Miracle last time. I can pay the balance that we did because we wasn't there. I was pregnant. Y'all not finna charge me for something that wasn't there. It wasn't no damages, not paying for damages.
She's not hearing you, Judge.
Ma'am, by all rights, okay, this is stuff that could have been argued back in 2020.
Exactly, but COVID came and I was sick. I got doctor's papers. That's what I'm saying. It's a lot of different stuff. Everybody just talking about what?
Well, okay, if people.
Okay, Your Honor, I had a baby.
Wait, ma'am. If people,
and I have doctor's papers.
Ma'am, oh my goodness. If people get sick or can't come to court, and
I went to the courthouse.
The proper thing to do is to ask for an adjournment or send a letter explaining what's going on. I've
been to the courthouse plenty of times, Your Honor. I have went down there and talked to the people. I paid the amount. I asked them what was next, and this is what they told me to do.
Ma'am, writing a letter, putting your issue in writing, serving the other side, and making sure I get it.
Okay, well, if I went downtown and I talked to people who know this type of
people in the clerk's office,
then why wouldn't they? I wouldn't talk to anybody in the courtroom. Nobody talked to anybody in the courtroom. Y'all was never available. I talked to the representatives or whoever you want to talk to.
Ma'am, we can't give you legal advice.
Oh my God.
That's not our function.
I didn't ask y'all for legal advice. I just asked for the next step. If I was supposed to write a letter, do you know that's all that needed to be said? I could have been wrote a letter. I can make payments today.
Well, that's
not a problem. I'm not paying for damages that I did not make. And that's the end of that. I have no problem with paying this. We can make payments today. We can settle this today, but I'm not going to pay for damages. So if y'all going to take the damages off, then we can solve it ourselves.
I tell you what I am not going to do. If you guys want to go in the breakout room and see if you guys can come up with numbers that everybody can agree with, that's fine. If not, I'm going to reschedule this. And ma'am, what you submitted to the court was just a little precipice here, okay? So if you disagree with their numbers, then what you need to do is put something together saying what you think the right numbers are.
Okay, Your Honor, I can do that. But when we was in front of you last time, you even talked to the lady.
Wait, ma'am, don't you understand why that's very important?
What's very important?
Nobody can address a moving target on either side. So they need to lay out their numbers, and I don't have it in the file. You need to lay out your numbers. It's probably a much
that was
more
never a problem, Your Honor.
It's probably
That was
much
never a
more.
problem.
It's probably a much more productive conversation if you guys exchange what you think your numbers are. You know, nobody can, swing at a baseball that they can't see.
Your Honor,
So, yeah.
our number is the judgment. If she's willing to pay the judgment discounted by whatever small portion is the damages issue, then that's a meaningful conversation. She's going to
More than
relitigate the
damages.
case.
I even got the other rent from the officer.
Ma'am, you don't have the floor. You don't have the floor. You are talking out of turn. Counsel. That is just pretty much what she's doing. Now, I told you both what it is I wanted you all to do. I want you guys to put your proposals in writing and exchange it with each other so that you can have a productive conversation. If it's back and forth or whatever. But you guys need to be looking at the same pieces of paper and have a productive kind of discussion. And ma'am, the same goes for you.
Yes, sir.
But this is not productive, what you guys are doing right now. Now, I'll send you guys into a breakout room, but I think it's going to be more productive if you guys have in front of you, because, ma'am, if you're going to dispute his numbers, you need to be specific about that. I mean, it sounds like you guys agree on one thing, and that is he's willing to knock off whatever he's saying is physical damage to the property. It doesn't sound like they're willing to knock off back rent.
They don't have to knock off that rent, but I did get the money from the officer to pay for September, so it should have only been October and December, and we left in December or the beginning of January, and I could pay the broken lease fee, but they got a whole bunch of different charges on here that's not even applied. But we can talk about it. That was never a problem. I just didn't know what the next step was.
But ma'am, that's the kind of thing that would allow you all to have a productive discussion. I mean, if you've got a receipt for some rent that they said that you didn't pay and you did pay it and you can prove it, then that's a worthy discussion to be having.
No, I didn't say so. Okay.
But ma'am, you can't just do a half-baked job of this. You got to get your numbers together and you got to get your justification for why you think your number is right.
And that's what I was trying to do, Your Honor. He wasn't the person who was in court with me last time. It was a woman. And you had told her that the damages she didn't even make sense. That's what you said out your own mouth to her. That's what I'm trying to get at. We can go from where you came off last time. You told the lady that none of that stuff made sense. That's exactly what you said. Now it's the man. I have no problem with talking to him, getting this off my name, because I'm ready to get it over with. I'm trying to move. But all of this stuff that they're charging me with, I need to make it make sense. And that's all I'm saying. Every time I talk to them, they didn't want to change the price. They had
the last time you were summoned to be here, February 20th, 2020, you didn't show.
No, it was me and the lady, and that was the last time I came. I had got sick. I got the paperwork.
I don't know when
COVID
the last
came
time
around. Y'all stopped doing for
I
it.
don't know the last time you came. I just know the last time you didn't come.
Okay, that's what I'm saying, Your Honor. I was in front of you before, and we said a whole bunch of different stuff that's not being said today. That's my only thing. But it's fine. I can
Okay.
talk to him, and we can work. I'm just ready to
All
get
right.
it
I'll
over
send you
with.
guys to the breakout room. You both go.
Okay.
Should be something, we're inviting them to join the breakout room.
I think she's already going.
He went before she did, so
They both in?
they are now.
All right, good.
Just a moment, I start the next case.
She wants to pay $20 every well, I can't tell if it's every 2 weeks or every month. She's checked 2 boxes here.
At the end, the lesson is simple. Take responsibility and be organized. Ignoring deadlines and relying on verbal agreements doesn't work in the legal system. Both parties need clear numbers, proper documentation, and productive discussions. Without that, time and resources are wasted, and the case keeps spinning in circles.